Okay, welcome everyone. Thank you very much for coming. I'd like to welcome you to our second talk today with Professor Emeritus Peter Hogg. We're so very fortunate to have him here with us and willing to do these two talks. As I begin, I should begin by acknowledging the fact that we are on Treaty 6 territory, which is the traditional land of the First Nations, Métis, and Inuit people who negotiated Treaty 6. And I am Pat Parody. I'm the Executive Director of the Centre for Constitutional Studies. This actually is the second lecture in our series this year, our events series, and it is our 30th anniversary, so we're very pleased in this 30th anniversary year to be hosting you, Peter. We've been trying to get you here for quite a number of years, so it feels like a bit of a coup. Anyway, of course, Peter Hogg is renowned as the constitutionalist extraordinaire, and so that's what makes it so very special for us to have you here. Now, before I introduce you, I'd like to just remind everyone to please turn your cell phones off or onto silent, and you'll note that we are videotaping the event. The video recording of this event will be available on our website in about a week or so. But if you don't want to be in the video at all, you could just move to the back of the room if you would, then that way you won't be part of it. We do have evaluation forms in front of you. We really appreciate your feedback if you have any. And of course, if you are not on our mailing list, please let us know. Leave us your email address and we'll include you. And so now, I think Professor Hogg is going to speak for about 40 minutes, and then we'll open the floor up to questions. And there are two microphones. I guess we would just need to use the one this evening. And so we'd ask that you go over there so that we can record your questions. I'd also like to acknowledge the presence of David Hancock, who is a justice of the provincial court, judge of the provincial court, but former acting premier of the province and former minister of justice. So welcome. It's nice to see you here. And now, I have the great pleasure of introducing our guest. Peter Hogg is best known as the leading authority on constitutional law in Canada, and though he has written several books, most of you will know that his Constitutional Law in Canada is his single most cited book, and it is the most cited book from the Supreme Court of Canada, which is interesting. It is, as most of you also know, probably the best resource on Canadian constitutional law for students, litigators, and scholars in Canada. And as Eric Adams said today at lunch when he introduced you, Hogg, as we fondly refer to you, can be found in every law school in Canada. So Professor Peter Hogg is New Zealand born. He was first appointed Professor of Law at Osgoode Hall Law School in 1970, became Dean there in 1998, and served as Dean until 2003. As Professor Emeritus, he continues to write and teach there, but he is also Scholar in Residence at Blake's, Castles and Graydon LLP, where he's worked on and off as Scholar in Residence since 1990. He's combined his academic work with a fairly robust litigation practice, having appeared as counsel in a number of constitutional cases, 15 of which have gone to the Supreme Court of Canada. For example, he was counsel for the Government of Canada in the Securities Regulation reference in 2011, the Assisted Human Reproduction reference in 2010, and the Same-Sex Marriage reference in 2004. He holds many honors. 1988 was named as a Fellow of the Royal Society of Canada. 1991 made an Officer of the Order of Canada. 1996 awarded the Law Society Medal for the Law Society of then, as it was then known, Upper Canada. 2003 promoted to Companion of the Order of Canada, which is Canada's highest level of that order. And he has honorary Doctorate of Laws degrees from several universities, including York, Victoria University of Wellington in Australia, and Université de Montréal. He also received an honorary Doctor of Laws degree from the Law Society of Ontario. So we're very fortunate to have Professor Peter Hogg, constitutional expert, here to present to us remedies for unconstitutional action. Thank you.
Well, thank you very much, Pat. No, I think I'm going to speak from here. I'll get my water. What I have done with this talk, and you've got the summary in front of you, is I've really just made a catalogue of the various remedies. There's a remarkable number of them, as you can see, that are available for unconstitutional action. They fall into two groups, and I don't know whether you've got two separate pages or a page printed on two sides, but on the first side of the page, I've listed the remedies that flow simply from the supremacy clause in Section 52 of the Constitution Act 1982. And on the second page, I've listed the remedies that flow from Section 24.1 of the Charter of Rights, the Remedies clause in the Charter of Rights. I don't talk about 24.2, which is the evidentiary provision. Though I've been writing about it actually as close recently as yesterday, because there was a recent decision on it. Anyway, that's what I'm doing, and it really isn't terribly original, but I think it might be useful to bring these various things together. Well, starting first with the supremacy clause, I've set it out here in the paper, and it's the provision that just says the Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. This has turned out to be an extremely important remedial provision, and it applies to all laws, and they can be invalid for any constitutional reason, including federalism, of course. In fact, it's the only remedy typically in federal cases, but it can also be used in charter cases as well. It doesn't have to have any particular process or procedure. It will simply apply in any proceeding where the impugned law is relevant. It will be open to whoever is resisting the application of the law to argue that Section 52 makes it unconstitutional. And then it authorises a variety of specific remedies, some of which I think are quite interesting. So let's roll down the list, starting with the most obvious one. In fact, for a long time, this was thought to be the only remedy for an unconstitutional law, and that's the declaration of invalidity, under which a law is declared to be invalid, and that, of course, is a declaration that has retroactive effect. Now, one disadvantage of the declaration of invalidity as a remedy is that it leaves a vacuum of law until the competent legislative body replaces the invalid law. So that's a downside, but it was never thought that there was any real escape from that until the Manitoba language case invented the suspended declaration of invalidity, where the law is declared to be invalid but maintained in force for a period of time, typically 1 year. And after the expiry of the suspension, the law would be invalid with normal retroactive effect. And the advantages of this is that it avoids the vacuum of law for the period of suspension. A second advantage is that the legislative body, not the court, designs the replacement law. A disadvantage, which is more theoretical than anything else, is that it does maintain in force an unconstitutional law. So that's what's radical about it. Now, I take some credit for this because it was invented in a case that I argued, the Manitoba language rights case. In the Manitoba language rights case, the Supreme Court had to decide what to do from a lower court ruling, which was clearly correct, that all of Manitoba's laws were unconstitutional. And nor was there any way to correct that because they were unconstitutional because they had not been enacted in English and French. They'd only been enacted in English since, I think, 1890. And what was particularly embarrassing about that was that the institutions which might be thought to be useful in correcting anything, like the legislature, had all been created by an invalid law enacted in English only. So it really was quite a tough problem, and it arose because a Manitoba driver, a francophone, was issued a speeding ticket in English only. And he brought the proceeding, there was a separate proceeding, although it was folded into this one. He brought the proceeding to have his conviction annulled on the ground that the speeding ticket was unconstitutional because it was in English only. So those are the kinds of things that great cases are made of. And there were a number of difficulties about it. I was retained by the federal government to try and find some solutions to this. And I appeared in court with a senior lawyer called Pierre Genet, with whom I'd done other cases, and so we tried to find some solutions to these problems. And the solution that we found was, and it hadn't been done before, was to suspend the declaration. Of course, these laws are all invalid. But we suspended, but the idea was we would get the court to suspend the invalidity over a timetable which would enable the province to gradually reenact the laws in both languages. That was the idea. One difficulty with that idea was that if the laws were indeed maintained in force, it meant that the man who got the speeding ticket would have to be convicted because the old laws were being maintained in force. And the then Prime Minister, Pierre Trudeau, was not normally hands-on in constitutional litigation, but because this was a language case, he instructed us that whatever arguments we made, it must not involve the conviction of the brave man who had brought the proceedings in the first place. And that was quite a tough assignment. Another part of it, which was a tough assignment as well, was he said, this again was the Prime Minister speaking, he said, the part of the argument that deals with the speeding francophone has to be done in French And I thought, well, that's no sweat. Pierre Genet was a francophone. However, what Pierre explained to me was, yes, he'd grown up in Ottawa, he was a francophone, but his law degree was from the Osgoode Hall Law School, and not a word of French was ever uttered in that institution. Actually, it is now, but it wasn't then. And he said, you know, I am a francophone, but it is not easy to, this was news to me, but it makes sense. He said, it's not easy to argue a legal case in French if you are educated in English. But anyway, I said, well, don't look at me, because I'm going to be hopeless. So Pierre had to get his act together, and he really did sweat over it to do. It was only a small part of the argument about whether there was some way of preserving the speeding driver from the consequences of the suspended declaration of invalidity. And I can't remember, I should have gone back and reread the case, I can't remember exactly what solution we found, but I think we tried to we successfully persuaded the court that they could treat the conviction of the driver as a separate proceeding which was occurring before anything was done about suspending the declaration of invalidity, and therefore he could be safely acquitted. Then we could move on to the reference dealing with the rest of the laws. So that there was a way of doing it which satisfied even Prime Minister Trudeau. So that is what the court did. It held that all of the laws of Manitoba were unconstitutional, but the declaration of invalidity should be suspended, and then a timetable was set up. You can't reenact all your laws in both languages in a year's time, so a timetable was set up, and as a matter of fact, there had to be later applications to the court to extend the timetable. But that's how that was done, and it was it was a good solution, I think, to a very, very difficult problem. It's interesting to notice, as everybody in the room will be aware of, that the suspended declaration of invalidity, which was so radical at the time of the Manitoba language rights case, is now used incredibly frequently by the Supreme Court, almost routinely by the Supreme Court. It is remarkable the number of cases where the court strikes down a law but holds that it can remain in operation for a year or whatever it may be, the advantage being that it avoids the vacuum of law and until the legislature or Parliament or the legislature has the opportunity to reenact and to enact a new law. So that's an interesting development, and as I say, it's now become so routine that we don't think of it as being radical at all. Severance. The idea of severance is that if only part of a law is held to be invalid, then that part of the law can be held invalid and severed from the rest of the law. And the doctrine that has developed about severance is that it can only be done when a court decides that the rest of the law can independently survive. Quite often, of course, what's invalid about a law would make a terrible mess of the law, and the rest couldn't independently survive. But mostly, for example, in charter cases, a search and seizure, this happened with the Competition Act, as it then was, I think it was the Combines Investigation Act in Hunter and Southern. There was nothing wrong with the Competition Act, but the search and seizure provisions of the Act did not comply with Section 8. They didn't provide for an independent judicial warrant before the Competition Bureau could seize all your documents. And so what the court did was it struck down the search and seizure provisions of the Act, but they were the only part of the Act that was wrong, and so the rest of the Act was left in place, but without those particular enforcement mechanisms. And of course, the Parliament moved quickly to enact new search and seizure provisions, which have been upheld in later cases. They read the decision very carefully before they drafted the new ones. So that's severance, and that is fairly common. Now, one that is uncommon is reading down, but I think this can be stated to be the law, although I don't have any actual examples of it. The rule is this: if a law will bear two interpretations, one of which is unconstitutional, then the law can be read down by holding that the constitutional alternative, usually the narrower version, is the correct one. And the advantage of that is that the statute gets narrowed in its scope, but no part of the law needs to be held invalid. Now, the last one in this litany is reading in. And I had a categorical statement in one of the sort of middle editions of Constitutional Law of Canada, which I thought I could say without fear of contradiction. I said, no court can put words into a statute which the legislature or parliament did not enact. That cannot be done. Well, it can be done. I've changed the text. I do change when it's perfectly clear that what I say is wrong. It takes me a while, but the case that illustrates this, I think it may be the only case that has actually done this, was the Vriend case, where the court actually added the word sexual orientation to Alberta's Human Rights Code so as to provide a remedy to a fired employee who was fired because, I can't remember if it was a he or a she, but he or she was homosexual. And that person would have had a remedy under the Human Rights Code in every other province. But in Alberta, they did not include sexual orientation in the Human Rights Code, and it was completely deliberate. It was argued, and the decision was made not to put sexual orientation in. So So when Vreen complained about not having a remedy for being fired because of his sexual orientation, he took the case on up to the Supreme Court, and the Supreme Court simply put the language in. And now that was very radical, because the Alberta legislature had debated the issue and had definitely decided not to put the words in. But the advantage, of course, was there was no need to wait for the legislature to do the right thing. The court was going to do it for them. So that made my statement wrong, and of course I had to then change it. Mr. Justice Major, from Alberta, of course, he dissented, not that he agreed with the fact that the person had no remedy. He said better to make a ruling and then wait for the legislature to act in compliance with the CCC ruling. But in fact, the majority didn't want to wait. They didn't wait. They put the words in. So I had to change my book and delete the passage that said one thing that no court can do is put words in a statute that have not been enacted by the competent legislative body. So they're no longer in the book. You can hunt for them. They're gone. You can see why it's interesting being a constitutional lawyer. You're faced with surprises all the time. Then I enjoy that. All right, let me turn to the second page and the other source of remedies, which is section 24 sub 1. 24 sub 2 is the provision that deals only with evidence. Section 24 sub 1 of the Charter of Rights is specifically a remedy clause. Anyone whose rights or freedoms as guaranteed by this charter have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. Now, I made some comments on the scope of section 24.1. It's only available for breaches of the Charter. Anyone whose rights or freedoms as guaranteed by this Charter have been infringed or denied, blah, 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 blah. So if a law is regarded as unconstitutional on federalism grounds, for example, you can't use section 24 to challenge the law. You have to go back to page 1 and section 52. Standing to seek a remedy is also limited because it has to be anyone whose rights and freedoms have been infringed or denied. So the fact that you may believe that a law is unconstitutional because it denies charter rights to somebody else, you have to get the somebody else to bring the proceedings. You can't bring the proceedings for somebody else. It's not an exclusive remedy. It's available alongside the supremacy remedy that we've just been talking about. And in fact, the cases indicate that for statutes, if the claim is that a statute is unconstitutional, even if it's unconstitutional on charter grounds, typically the best solution is to use the supremacy clause and get a declaration of invalidity. So you'll find that mostly when the challenges to an entire statute, the Section 52 and the Declaration of Invalidity is the remedy of choice. What is the usefulness of 24(1) especially, though, is for acts by government officials. Of course, the Charter only applies to government and government officials, but for acts of government officials, 24(1) will be available and will provide a personal remedy that is appropriate and just in the circumstances to the successful applicant. Now, it has to be a court of competent jurisdiction. That's created quite a bit of litigation, but I think the way it has fallen out is the way I've set it out in the paper. A superior court is always a court of competent jurisdiction. An inferior court is a court of competent jurisdiction where it is the trial court and charter issues arise in the course of the trial. And that happens a lot, of course. For example, a claim of a failure by a prosecutor to make full disclosure to the defence, as required by the Stinchcombe case. That claim would make an inferior court a court of competent jurisdiction, because it's the trial court and the charter issue has arisen in the course of the trial. Now, after some bumbling and mumbling, the court has also held that an administrative tribunal can be a court of competent jurisdiction if two conditions are satisfied. One, it must be an administrative tribunal with authority to decide questions of law. As you know, there are some administrative tribunals that do not have authority to decide questions of law. But if it has authority to decide questions of law, and secondly, has the power to grant the remedy that is sought, then Section 24(1) can be used against an administrative tribunal. The only case I've cited there is not a great authority for the point, but in the Conway case, the judicial review of a decision by the Ontario Review Board, that's the board that deals with detentions of people who are not guilty by reason of, you're not allowed to say insanity anymore. I'm not sure what NCR does now. I've always liked insanity, but not criminally responsible. Yeah. So when an NCR prisoner sought a remedy for a decision that kept him in detention, the court held that the Ontario Review Board would be a court of competent jurisdiction for some remedies, but apparently it lacked the power to grant an NCR prisoner, not criminally responsible by reason of mental disorder, an absolute release from custody. The Ontario Review Board did not have that power. And in Conway, what Mr. Conway sought was an absolute release from custody. That could not be done under Section 24(1) because the Ontario Review Board did not have the power to do that. The range of remedies is under the Section 24(1) is very wide. The only restraint in 24(1) itself is that they must be appropriate and just in the circumstances. But obviously that gives to the judge a very, very wide discretion. There have been a couple of cases in which damages have been awarded. The most outstanding of these cases is a case called Vancouver and Ward, which was a case where an innocent man, he happened to be a lawyer, which was the reason, no doubt, that the case did go on up. The police made some ridiculous mistake. They had been alerted that someone in the crowd in Vancouver was going to throw a pie in the face of Prime Minister Chrétien, who was then visiting Vancouver. Now, you would have thought that a person who was not carrying a pie could be pretty much forgotten as a suspect, but that was not the police view. They arrested Mr. Ward. They strip searched him. You never know where you will find a pie. And they held him in custody for 4 hours. Now, we can all agree he was certainly entitled to some damages. What I think most of us in the room would say, though, was the damages that he was given were pretty miserable for this treatment. He was awarded $5,000 as charter damages and $5,000 as tort damages for the tort of holding him without a legal arrest. So he got $10,000 for this. But anyway, it does illustrate that damages can be awarded, but it doesn't particularly encourage people to seek damages. Certainly, people who understand how much their lawyer will charge them to seek damages will be put off by those numbers. In quite a few cases, a costs award against the Crown has been used. And as you know, the Crown, in criminal cases, the Crown does not pay costs, or nor does the defendant. But so for breaches of, for example, the Stinchcombe duty of disclosure, which, if it's not complied with, at least leads to substantial delays in getting the case done. In some of those Stinchcombe cases, a costs award has been made against the Crown as a remedy under Section 24. And the other remedy which is available is the point that I don't want to talk about, that is exclusion of evidence is another option, where evidence has been obtained in breach of the Charter, but I don't want to go into that here because you will recall that what Section 24(2), which I did not recite at the beginning, is the one that says that evidence obtained in breach of the Charter shall only be excluded if its admission would bring the administration of justice into disrepute. And those of you that have paid any attention to that provision will find that it has been the subject of very much litigation. And so I'm not going to, it's too difficult, I'm not going to talk about it. And but exclusion of evidence obviously is one of the remedies that is possible if you can get over the bringing the administration of justice into disrepute limitation. Well, that I think is the whole range of remedies for unconstitutional action. I've finished, but I'd be very happy to answer any questions or listen to any comments.
Please feel free to just go to the mic and ask a question. You've intimidated the group.
Professor Hogg, good evening. My name is Paul Moreau, and I'd like to start by saying it's an honor to hear you speak. I think all of us grew up as lawyers on your constitutional law text. I wondered if you had any comment on the recent, well, I'll call it a rash of decisions dealing with the unconstitutionality of minimum mandatory penalties in the Criminal Code and the Controlled Drugs and Substances Act. I'm sure you're aware that a number of provisions have been struck down by various courts, including the Supreme Court of Canada. Do you see this as being a trend? Is it a reaction to the Harper government's numerous amendments to the code? And do you see a future direction in that regard?
Before the Harper government took office, I was quite sympathetic to the idea of having minimum mandatory sentences, because it seemed to me that whenever you read any study of sentencing, which of course is always done by the discretion of the judge, what it always shows is that there's just enormous variation in the sentences that are awarded in what are apparently very similar situations across the level of courts. And so it seemed to me, and you know, the Americans have, they don't have mandatory minimum, but the Americans now have a code of sentences which can be departed from, but which is designed to make it more uniform. So I thought, well, mandatory minimum sentences are not a bad idea because at least the judges have to obey that. And, but of course, it soon turned out that the mandatory minimum sentences were often completely inappropriate in some of the cases under which they were caught. And you started to see some argument for judicial discretion here. And so I have turned around on that issue, and I agree that that mandatory minimum sentences are a bad idea, and you will always find cases for which the sentence is not appropriate, and I don't see why an inappropriate sentence should be imposed just because of the mandatory minimum. So I think the courts are now on the right track with that.
Professor Hogg, you talked about how suspending the declaration of invalidity has now become sort of the standard practice of courts when they find a law to be unconstitutional. And it seems there's quite a range of times that they could pick. You have the Manitoba case where you had a several-year timeline supervised. You had the British Columbia Court of Appeal when they found for marriage equality, and then they suspended that for 2 years, and then the Ontario Court of Appeal basically exploded that timeline. You have had numerous very large cases where governments have come back and asked for an extension that the courts have then given. So what guides how long of a period that you pick, or if it's just, well, a year seems like a good amount of time, is that the best process?
There's absolutely no evidence that, although I don't doubt that judges do think about this, but they rarely put into their judgments any reasoning about the length of the period of suspension. And I think it's fair to say that 1 year has been the popular solution, but you're right. There have been other cases where longer periods of, what I can't remember is when they have ordered a longer period than 1 year. Do you know if there has been any sort of explanation of saying, well, we're going to do this for longer than 1 year, and the reason is, well, the reason would presumably be that it's difficult in 1 year to correct the constitutional problem. But I don't recall. I don't recall. In fact, I don't recall any discussion of this. No, so it's perhaps a legitimate criticism of the judiciary that there's often very little discussion of quite important remedies when the substantive. The substantive case has not been dealt with lightly, but the remedies sometimes appear as though they have. So I don't know the answer to that. Yes.
Hello, Mr. Peter Hogg. Nice to meet you. My name is Mohammed Arshad, and I'm a law student here in UFA. I have a small question, very, very short question, about your book. I study your book about Constitution many a time. And we see a lot of examples from Australian law and USA. You quote a lot in your book. So sometimes as a student of law, we are confused. Is the book, it's a huge volume? And this is my question.
Well, I know there's a school of thought in the United States at least, although hopefully it's diminished with the death of Mr. Justice Scalia, that there's no point in working from the precedents of other countries because every country is unique. But I started writing about the Charter of Rights before there were any cases, except for cases at very low level. And so I had to start writing with very little guidance. And what I did was I made very heavy use of what the Americans had done about the comparable right. Most of the rights, as you know, have their comparison in the not all of them, in the American Bill of Rights. And so that accounts for some of the American references. I don't know about Australian references because they don't have Australia doesn't have a Bill of Rights. I've used Australian references for some issues which are comparable here, but not for the Charter of Rights.
Thank you very much.
Alberta Justice. We have on our team at Alberta Justice, Constitutional Law, your loose leaf on all of our desks. So just give us more law, we'll need more people and buy more books. A practical question that often comes in the office is about constitutional notice. And I think it's fairly clear that if someone is still arguing for the remedy that a section must be interpreted their way to be constitutional and any other interpretation is not constitutional, that we still need notice. But I get the impression that the profession doesn't always know that, or there's vagueness in that. They say, I'm not trying to strike it down, I'm not trying to strike or get certain other remedies. Are you aware of any other case law or concern where that's been dealt with or resolved or clarified for anybody?
No, but I have had the problem myself, in designing these, or in deciding whether a constitutional notice has to be served, and it's made more difficult by the fact that each province has its own requirement, of course, as does the feds, and they're not all expressed in the same language. And I'm sure that's exactly what you've noticed. And so you do get issues about, well, I'm not really attacking the law, I'm just saying that it's been interpreted in a way that was unconstitutional, something like that. And for most of the notice requirements, it's pretty clear that that does require a notice, but it may be that for others it doesn't. And it may be too that the lawyer doing the case doesn't think of it as a constitutional case and doesn't remember that he probably should be filing a notice. So there's quite a few cases in which notices are not filed, and the courts have sometimes been a bit ridiculous about it. There was a case. Was a case in the Supreme Court. It's one of the last. It's one of the last AMPS cases, the administrative monetary penalty cases, in which a man, the lawyer was a criminal lawyer, and he was, I think, challenging the constitutionality of a law that applied to his client, but he didn't think he was. He thought he was just saying that it should be applied in a certain way that would be constitutional. So he didn't serve a constitutional notice, and he even didn't serve a constitutional notice when it was pointed out to him in the Court of Appeal. I wish I could remember the name of this case. My memory is shot. Then in the Supreme Court of Canada, he did finally file a notice of constitutional question. And to my astonishment, two of the judges, Abella was one, and I wouldn't have expected it of Abella. Abella was one, and I can't remember who the other one was. They refused to decide the case, because although he had filed a notice of constitutional question in the Supreme Court, he hadn't done so in the lower courts, and what changes that might have made to the record that would have been produced. You can see the argument, but it was really pretty ridiculous to not decide the case, and that's what they did. They didn't decide the case. So it's a pretty important requirement, and if you're in doubt, you should do it. I'm speaking to the converted when I tell you that. But it's lawyers who don't do very much constitutional law often, don't realise that this is something they have to think about.
Good evening, Mr. Hogg. It's nice to see you here. I recently passed my NC exam by reading your book, and I want to admit that it's a wonderful book. And my question is that I did my law from England, and even over there, when they find a law which is unconstitutional, they declare the Declaration of Incompatibility, which is very similar to what we have in Canada. When we talk about separation of power, court's job is just to interpret the law according to the will and purpose of the legislator. So where do we get this power to render a law unconstitutional? Because judge's job is just to interpret the law, not to make the law. Would you please shed some light on it?
I'm not sure about the answer to that question, but I think we're talking, which country are you talking about here? Is it the United Kingdom or the United Kingdom? New Zealand has the same problem, and in both countries, the Bill of Rights is not a constitutional instrument, and it does not give a right to strike down laws. So what the idea is that courts would say that a law was inconsistent with the Charter of Rights, but would not strike it down. And the political and civil service would take note and that it was contrary, and the law would either be fixed up or would be ignored. I think the problem with not having that power is that it does leave if the judge doesn't say something emphatic about it, it does leave a law that the judge does believe is unconstitutional, or at least contrary to the Charter of Rights, in place without any proper. And so I don't think that in both the UK and New Zealand, the courts have taken on the power to say that a law is contrary to their Bill of Rights, and I don't think they need a special power to do that. That's just part of their reasons, and I think it's a good idea.
Can I speak?
Yes, it's your turn.
Thank you very much, Professor Hogg, and very enjoyed your lectures, all the information. I want to clear your opinion on today's legal aid of Alberta. In my understanding, in the 1960s, start with legal aid discussing legislatures, because without lawyer, there's no judges. Even today, many media, loud voice, there's increasingly called SRL, self-represented litigants. Increasingly, not reduced. But important, my question, make it simple. I believe this covered is in the Constitution. Because today, legal aid Alberta refused to support, give your lawyer help on charter cases. Do you think that's constitutional? I personally feel it's against Constitution.
Why do you think it's unconstitutional?
Constitution is to protect the integrity of justice. Today, without a lawyer, there's no justice. That's fact proved. Everybody agreed. Almost the articles, lawyers, they're talking about no lawyers, no judges, no access to judges. You just waste your time, waste your money. But the people continue because that's the only result in Canada, the court, we have to get justice. But frustrated, whatever get, but one of them, we just continue fight because justice is holy, is very important, is kind of soul of the nation. We can't ignore it, but the court, as I know, many judges, they just hear any words, right or wrong, the lawyer's side. If the other side with the lawyer, they just even whatever your language problem or your writing, even writing clearly in the affidavit, they ignore it. You can, any common sense, in my case, many times, any have common sense, put both sides, the lawyer side, the side without lawyer, their facts, it know what's the right and wrong, so clear, obviously. But the court ignores. With some joking, once a lawyer say, "Oh, you don't have a lawyer. You walk in the court, the naked, can seems indecent." Whatever the facts according to our society, my point is, certainly I'm not a lawyer. I have the humble to give my opinion to here. Because that's your lecture encouraged me to speak some my faith and my feelings and my knowledge. And important is the facts, the reality today in court, at least in court of Alberta, my personal directly. There's no justice, no lawyer, that's the facts, whatever case. And important, having finished fighting with the legal aid refused support charge case because that means government officials much bigger than the law. But the legislation, the Constitution didn't say that. Constitution is the highest authority in Canada, at least in Canada. I don't know other countries. But the legal aid don't support anyone to fighting with government because the government wrong. He's representing government, giving the money, something like that kind of nature. Who gave the money? He's working for whom? Because that's not justice. That's obviously against law, against justice, against the esteemed name of Canadian judicial system. I feel that way. I want to have your opinion. I know my word, humbled, limited. Thank you.
Thank you. If the objection is to people appearing in court without lawyers, it obviously is a disadvantage for them, but a lot of people do that because they can't afford a lawyer or because they don't believe a lawyer will advance their case as well as they would do themselves. So it's hard to be dogmatic about people appearing without a lawyer. It's obviously it's usually a disadvantage, but there are many cases where litigants do represent themselves.
Thank you.
Hello, Professor Hogg. I have a federalism question for you, but I apologize if you wanted to get out of the province because it's about pipelines. So I'm not, but if you have any comment on provincial jurisdiction compared to a national energy board or of current events, it'd be appreciated. Thank you.
Provincial jurisdiction over projects that have been approved by the National Energy Board? Well, I do not believe there is any provincial jurisdiction over projects that have been approved by the National Energy Board because they have been approved federally, and the project is within federal. I'm assuming that it's an interprovincial pipeline, or so it's within federal jurisdiction. And I know in BC the theory is that you can kill pipelines by 1,000 cuts, every municipality. But I think there should be some injunctive relief sought to prevent municipalities from derailing a federal enterprise that has been approved by the federal government whether through the National Energy Board or not, but whatever is the process. And there should not, I don't know how you stop all this death by 1,000 cuts, but one of the things that I had once suggested, but I don't think anyone paid any attention, was that perhaps you could get a blanket injunction to stop people from doing what they say they were going to do. That this is obviously going to go on for a long time. At one point, when the NDP government was elected in BC, the leader said that he was going to use everything possible to stop the federal pipeline projects going through the province. And I thought that might be the opportunity to seek an injunction, and the injunction would be against exactly what he had said he was going to do. But anyway, nobody did seek that injunction, and so we do have a bit of a chaotic situation there. And perhaps the injunction wouldn't have helped anyway. But I suppose I'm a typical lawyer. I think that legal remedies can usually do the trick. Often they can't.
Hi, my name is Randy Williams. I'm an artist. I've also read a number of your books. I'm a teacher, I'm a certified teacher at Alberta, and I was a certified teacher in BC. But recently they had a policy that you had to have a vulnerable sector check and a criminal record check every 5 years. And so this second 5 years where I would have been certified in BC, they wanted me to have this vulnerable sector check and criminal record check done. So and I went to the RCMP building and I got them to give me a copy of what they're using for the checks, because the vulnerable sector check apparently is not based on your name. It's based on your gender and your date of birth. And so what BC is doing, because if you don't voluntarily submit to fingerprinting all 10 fingers, the province of BC, they get back an incomplete from the RCMP, and that means they'll expunge your certificate in BC. So I earn my living not through teaching, but I just thought it was so extraordinary, and I read your books. I just thought I'd bring this to you and give it to you. It's just amazing that teachers are losing their certificates only because they won't voluntarily submit to having 10 fingers fingerprinted. And from what I understand, the reason for the policy is that apparently Graham James, the hockey guy, he changed his name and was able to pass the vulnerable sector check, or not even be checked for whatever reason he got through it. So that's my understanding of the reason behind it. But to me, this is so broad. It's going to, I mean, if I were earning my living as a teacher, it would matter to me more. But I just find it extraordinary that this is going on, and no one seems to care or mind that it's happening. But anyways, if I could just give this to you.
Yes, no, I
sure.
do.
Thank you. And I really enjoyed your books too.
Thank you very much. Well, I won't attempt to comment on this now because I haven't read it, but I will read it with interest. So thank you very much for the comment.
Professor Hogg, thank you for coming today. I really appreciate it. I've actually got a question for you about severance. On its surface, severance seems like a nice and tidy remedy. The court gets to strike down an offending provision without sort of disturbing the rest of a larger scheme, whether that's the Competition Act or the Criminal Code. Unfortunately, it seems like our legislatures have been a little slow to clean up some of these provisions, these zombie provisions left behind. Do you think the court should take that into account when they are deciding which remedy to use and perhaps choose some other remedy over severance, perhaps a declaration of invalidity or a suspended declaration?
It's a very, very good point because I gather that when, for example, I think the criminal code is particularly vulnerable to this, and a provision in the criminal code will be held to be unconstitutional, and nothing is done to change the text of the criminal code. So if the reader has followed all of the cases dealing with the criminal code, hundreds of cases dealing with the criminal code, and they remember them, then it may not be so difficult. But there really should be some routine revision of legislation that is held to be partly unconstitutional. And I don't know whether it would be inappropriate. I suppose a judge might say this goes beyond his or her usual domain, but it would be at least sensible for when a court does this, say, strikes down a small provision of the criminal code, that it says at the same time, and obviously it can't change the Act, although I don't think it can change the Act, but to say at the same time, and I am trusting the Department of Justice, if it's a federal case, or the Ministry of the Attorney General, whatever it is, but those lawyers will be in front of the court, to make sure that the legislation is corrected so that it doesn't continue to advertise an unconstitutional provision. But I think that's all that the court can do. I don't think they can. It's really just sloppiness in the revising of the statutes. And if you have it's not a sufficient answer, to me at least, to say, well, we revise the statutes every 25 years and, we'll fix it up then. So, wait for 24 years and we'll have it done. But for 24 years, that provision stays in the statute, and there's no reason for anybody to think that there's anything wrong with it. There might even be, I don't know, I'm such a dummy on technology, but you would think that even with printed statutes, there might be a possible way of noting. I suppose once the statute is published, it would involve a great deal of, maybe I won't pursue that. But yes, yeah. No, that's a problem. And governments, I'm sure governments differ, but some governments at least don't seem to care about it. Well, I think we've probably exhausted our questions.
Yes, well, I just want to thank you so much for your thoroughness. And certainly tonight's lecture is an example of how thorough you are, and we're very thankful to you for the way in which you are thorough with your constitutional law of Canada, because as many people have indicated this evening, they've learned a great deal from you. And so we hope that you continue in your work updating that enormous tome. And it's nice to know that you correct yourself, unlike the legislature, with respect to the criminal code.
I'm better than the legislature.
Yes, you are. Clearly, that's just... So we have a small gift for you here to thank you very, very much, Professor Hogg, for coming out. And just so you know, today Professor Hogg did a podcast with Professor Peter Carver, and that will be available on our website as well. And it's basic questions that I think would be of interest probably to many constitutionalists.
I think so. I was actually astonished at how penetrating Peter's questions were, and I really enjoyed our interview. I enjoyed it because it was challenging.
Good for you, Peter. Anyway, so that will be available on our website as well. So thank you very, very much for coming out to frigid Alberta and being a true Canadian. We really appreciate it. Thank you.
Well, thank you very much, Pat.
And thank you very much for coming out. And please do fill out your evaluations if you might. We'll pick them up after you.